Hello everyone, this is Tom Fox. I'd like to welcome you to episode 291 of the FCPA Compliance Report. The FCPA Compliance Report is sponsored by the Red Flag Group. The Red Flag Group is a business advisory, information services, and technological firm that helps corporations, financial institutions, governments, and SMEs to manage their integrity and compliance in their businesses and across their third parties. You can check out more information on the Red Flag Group at their website, www.redflaggroup.com. Today I have with me Sara Kropf. She is the principal at the Kropf Law Firm. She is a white-collar defense lawyer. She is a former partner of a big law firm in Washington, D.C. and went out on her own a few years ago to start a boutique trial criminal defense trial practice. She blogs weekly at the Grand Jury blog, which is one of my favorites. She talks about things from the white-collar defense perspective, and I always find her views and insights very interesting. So after you listen to this podcast, you should check out her blog post, Grand Jury Target Blog. Sara talks to us about how she would think through defending an individual employee in a white-collar case, whether that be an internal investigation or if one is called by the government. It's a really interesting insight onto areas we don't really get to explore a lot on this blog, which is the defense side of an FCPA investigation. I think you'll find it very interesting and certainly useful for the compliance practitioner going forward. This is Tom Fox. I'd like to thank you very much for listening to this episode of the FCPA Compliance. Hello everyone, this is Tom Fox, and I'd like to welcome you to this episode of the FCPA Compliance Report. You're in for a real treat today because I have Sara Kropf. Sara is a white-collar defense lawyer in the Washington, D.C. area. She's a former big firm partner, and most relevant for me, she has one of the coolest blogs out there called the Grand Jury Target blog, which she started in April of 2013. I am an avid follower, and my only criticism is that you do not post enough, because I love your stuff. So with that somewhat long-winded introduction, Sara, thanks very much for taking the time to visit with me today.
Great. Thanks, Tom. I'm happy to be here.
So I looked at your profile on LinkedIn, and you did come from big law, and you looked like you had a good background of white-collar defense, RICO cases from, as it says, from large multi-week trials to smaller state trials. So you know your way around the courtroom. What led you to go off and found your own firm?
You know, there were a lot of reasons. I actually loved the firm I worked with, which was, I'm sure you know it well, in Houston. It was Baker Botts, and I spent about 10 years there and really enjoyed it. I just found that I wanted to represent individuals, and unless the individual is indemnified, it's so hard to find individuals who really can afford big firm rates. And plus, I loved trials, and the cases are always so big at a big firm that I thought going out on my own, I had a better chance of getting trials. It turns out it's almost as hard to get trials out on your own as it is at a big firm. But, you know, it's nice to have say over my practice and not quite as much bureaucracy. I
listened to a podcast with Steve Sussman, if you know who he is, a big time, or at least a famous trial lawyer from Houston. And he started a new project at NYU Law School, his alma mater, to try to get more jury trials going. And he gave the stunning statistic to me that there are now an average of 4 to 6 trials each year in federal district court, which I just found that mind-blowing. Everything else settles out.
That's incredible.
Yeah.
Yeah. So, I mean, it is disappointing, but the stakes are often so high, particularly in criminal cases, but even in civil cases, that it's so much easier and less risky to settle or to plead out.
So your blog is really what kind of led to this conversation, because I have to say that you are, it's not you that you're unremitting in your criticism of the government or the Department of Justice, but you will call a spade, and when you see something that you think has been done incorrectly or positioned that is not supported by what you at least articulate as relevant case law or precedent, you will call out that party, and kudos to you for doing that.
Well, thank you. I mean, I try to be fair. I will say my friends who are prosecutors think I'm not exactly fair. And full disclosure, my husband works on the civil side of DOJ, so I get it at home as well if I'm being unfair. But you know, I think you do. You know, you have to look and see who's doing what, and I learn an incredible amount. I'm sure you do too by blogging. I mean, that was one reason it was suggested to me to do it, which it was a great way to keep up with what's going on, and that's one reason I do it. I do it for my readers, but I do it also for me. It keeps me up on case law and what's going on strategies people are using that work and that don't work. I'm probably a little gentler on defense counsel though, because I know how hard it is.
Years ago, I used to write and speak when I'm a recovering trial lawyer. I used to write and speak, and I learned very quickly that to write or speak on a subject, I had to actually research it and learn it. So that kind of dual function of learning something and then being able to publicize yourself, I found a great boon back in the day when I was actually practicing law.
Yeah, I agree. And you know, there are certainly times when things I have blogged about that I didn't know much about then have come up in my practice, and I'm eternally grateful for having already researched it, already looked into it. And plus, I do think, you know, in keeping with this podcast, it's an amazing way to connect with people who you may never meet otherwise. I mean, I've written posts and had lawyers reach out to me saying, you know, my client went through exactly that, and DOJ treated them this way, and so it is a great connector among the defense bar, particularly solo and small firm lawyers who reach out. And I always encourage people I know that if they have a great topic to let me know, because you know how hard it is. Coming up with ideas to me is much harder than the actual writing. But coming up with things that I think are interesting enough to write about that I'm not bored researching or writing, it definitely takes some time.
Well, you, in addition to having a great blog that I certainly read every post, do you post weekly, it looks like?
I try to. That is the goal. If you looked recently, I think it's been about 11 or 12 days, but my goal is to post weekly.
Well, let me just reemphasize my complaint of you need to post more. But what I really wanted to
I'll take it under advisement.
Okay, what I really wanted to visit with you about was more than simply your blog, which is your experience as a white-collar criminal defense lawyer. Because as you're very well aware, the Yates Memo came out a little over a year ago, and I think that changed the landscape of corporate internal investigations and then the relationship of the government, internal investigators, and corporations to individual potential defendants in cases. And I really wanted to explore some of those issues from your perspective and how you might counsel someone who would come to you who has been asked to give a voluntary interview in a corporate internal investigation around really any kind of white-collar crime. But as you know, I'm kind of playing the FCPA space. So how would you counsel an individual, or how would you even start with that process?
You know, I think the first step is always, for the client's sake and for my sake, is to figure out if they're indemnified. And that oftentimes is the client's main concern, is how in the world am I going to pay for a lawyer, no matter what kind of case it is. So that is often the very first step, is to figure out that side. Once I figured that out, you know, it's an interesting situation. If the person is a current employee, they essentially have to consent to being interviewed or face termination. And so in a sense, there's not much choice to be had, unlike if it's just a straight government investigation where you have a choice to go in and be voluntarily interviewed or not. In an internal investigation, you generally don't have any choice whatsoever. So that changes the strategy a little bit. Assuming my client has realized that he or she will be interviewed, doesn't really have any choice in the matter, the first real step I'm going to take is to reach out either to inside counsel or outside counsel, whoever got in touch with my client, and talk to that person, because my goal is to find out as much as I possibly can at the outset before the interview of what's the scope of the investigation, what are they looking into, is the company already talking to the government or are they not talking to the government, what's the timing. A lot of those things company counsel will not tell me, I mean, to be totally frank, and I understand why. I've been on that side. But that's going to be my first step, is what information can I find out, in part because it may put my client at ease, which is the goal is to get the client through the representation, facing no liability, but also with their sanity intact. So I'm trying to find out as much as I can, and that would be my first step.
So in your mind, does the Yates Memo change the calculus at all if a company is required to turn over information on individuals really as quickly as they can, or in terms of how they would approach an employee or what that employee's procedural rights might be?
There's always the risk, of course, even before the Yates Memo, that the company was going to turn over whatever they found about the individual. It may change the timing. I always have a preference for pushing it later rather than earlier, if I can. And I do think it changes, and I think this is unfortunate, it changes the relationship between that, let's say it's an executive or a director, and the company. I think there's much less trust there. I think as what I usually am, which is counsel to the executive, is I do have to be cautious with my dealings with the company, more so than I used to in the past. I mean, the white-collar bar is a fairly tight bar, and I get a lot of referrals from company counsel who trust me, who know me, and are willing to work with me. And I want to keep that cooperative relationship, but at the same time, I have to represent my client the best way possible. And so it's, I think, a little bit more standoffish between counsel for the individuals and counsel for the company. That, in turn, I think can harm the company, because my client is going to be necessarily more concerned about disclosing things, and I'm going to be counseling them that it's likely, if not definite, that the company is going to turn that information right over to the government. So I do think it changes things. I don't think it's a sea change in anything. At least I haven't seen it in my practice. It certainly changes what I tell my clients and the things they need to be worried about.
In terms of you, I'm glad you mentioned the relationship that you would have with either the corporation's in-house counsel or their external counsel, and that's a factor that gets really a lot more done than non-lawyers understand, is having that professional courtesy and professional trust. Do you think the Yates Memo negatively affects that?
I think it does. I wrote a blog post about whether or not it meant joint defense agreements were going to go by the wayside.
Right.
I haven't seen that happen, right? I mean, certainly we still operate in almost every situation with joint defense agreements. I mean, that is how you get things done. And especially as outside counsel to an individual, when I don't have access to documents and emails and all that, I want to work cooperatively with the government. I mean, with the counsel for the company. But I do think it has changed the relationship, because what I have to advise my client is, as soon as we tell the company anything, assuming they are in a situation where they are cooperating with the government, which seems to be obviously more often than not, they are going to tell the government everything. They can't pick and choose. They can't, in theory, they can't not change what you're saying, but make what you're saying fit the narrative that they are telling. They need to tell the government everything, and that is incredibly scary for executives. And so it encourages them not to cooperate with investigations. Now, frequently they have to cooperate because they can't risk losing their job, but I think it has absolutely changed that relationship between the company and their executives.
One of the things that I've, if not worried about, have wondered is if a company is turning over information or intends to turn over information to the government, should an employee be given any sort of Miranda-type warnings or warnings beyond simply the Upjohn warnings? Is that anything that you've considered, or am I just too concerned?
I mean, I wish they would, but I don't think they have to. When I was on the side of representing more companies, when I was at a big firm, it is a painful thing, I think, for anyone, but particularly as a lawyer, to interview an employee who is not represented and listen to them essentially incriminate themselves. And that's hard to watch. I mean, for any person, if you have a conscience at all, that should bother you. At the same time, the obligation of company counsel runs to the company and not to the individuals. And so, no, I don't think you have to give any sort of Miranda warning. I don't think you have to advise about their rights. In fact, it probably is in the interest of your client i.e. the company, not to do that, because you want that individual to tell you everything that they know as freely and as openly as you can. So that does not, however, preclude you or someone else as company counsel from saying to your client, hey, I think we should at least let folks know that we will provide a lawyer for them, that they have certain rights that they probably want to talk to a lawyer about. You can't advise them, but there's something that stops company counsel from, at least with the permission of their client, telling individuals that the company will provide counsel for them if they want. I've been in a lot of situations where I'm representing individuals, and frankly, the company that they work for is doing everything right. I mean, they are providing counsel to people who may face any liability, or anyone who's going to be interviewed by the government. They're paying all the fees. I mean, they're really being, I think, a corporate good citizen in that regard. So but no, I don't think company counsel, inside or outside, has any obligation to tell an employee that they face any liability for what they're saying to the outside counsel or inside counsel.
Sir, let me pose this question to you. You have a client who's an employee, an executive in a corporation. You're representing him under an indemnity, and out of sort of the blue or nowhere, it turns out the government wants to interview your client rather than the company. What would you advise your client, if anything, differently at that point?
I'm not sure I'd advise them any differently as far as how we're going to prepare and what to do and what not to do. I would, in almost every situation, seek my client's permission to let the company know that the government has reached out directly, particularly if I'm in a joint defense. That is information that is obviously frequently shared and would be expected to be shared. And could, if you didn't share it, be a reason that you really need to withdraw from the joint defense. But so I'd want to do that, in part because the company may have information about why the government all of a sudden is interested in my client. So that information gathering stage is going to happen first. With respect to my client, in that situation, I'm going to do the same thing as I did with an internal investigation. I'm going to reach out to the government and ask, why they want to interview my client. What's the scope of it? Is there a time frame? And obviously we're going to talk about Queen for a Day proffers and all those sorts of things that will happen early in it. But I'm going to try to find out from the government why they want to talk with my client. And from the company's perspective, I do probably want to let them know that the government has reached out directly to try to interview my client.
I have a lot of folks that listen to this podcast who are not criminal defense lawyers. Could you explain what a proffer is? Sure.
So a proffer is when there's several different types, but the most common one is where the lawyer goes in either alone or with their client to talk to the government voluntarily. So an attorney proffer is when just the attorney goes in and says, if you talk to my client, here's what my client will say. And you'll basically give a description. You may answer questions from the government. What would your client say about this? What would your client say about that? A proffer, there are also proffers where you bring in your client, and those are roughly the same thing as a voluntary interview. You might go in with certain protections that are very limited, but the government would essentially interview your client, and your client would proffer to the government, here's what I would say if I were testifying in court or in front of a grand jury. So a proffer with a client is the same thing as a voluntary interview.
And once again, could you explain, because most of my listeners would not understand, what does it mean for someone to be called in front of a grand jury? Would they have you or other counsel present? How would that process work?
So the grand jury it's in a way a mystery. I was never a prosecutor, so I've never been in a grand jury. But a grand jury is convened by the government, and it's the device that the government uses to investigate a potential crime, to issue subpoenas. The grand jury, which is made up of 18 regular citizens, you can get called for jury duty in the grand jury, would be in the room along with the prosecutor. If my client were called to testify, they go in and testify before the grand jury, being questioned by the prosecutor, but I am not in the room with them. So they are in there alone, which is an unbelievably scary process for anyone. No matter how sophisticated an executive, a grand jury appearance is terrifying. I'm right outside the door, and they can come talk to me whenever they want, but usually they stay in and they answer the questions. So a grand jury would look fairly informal. The jurors would be sitting there, the prosecutor would be sitting there, but the individual is testifying under oath, and everything is being taken down by a court reporter, and it would be testimony that's used to prove a crime.
So one of the at a conference I was at recently in New York, Richard Bistrong spoke, and he's fairly well known in the FCPA community as the cooperating witness the government had in the gun sting trials. And he said that based on what he knows today, if he were a senior executive and was asked to make either make a voluntary statement to his company or to come in for an interview, and he had any concerns, he would want to go directly to the government for two reasons. One would be to try to cut the best deal he could for himself. But his second point I thought was equally interesting, which is he would want the government to hear his story unvarnished or without the spin a corporation might put on it. Do you find either one of those to be valid, and how would you proceed in that situation?
Well, I can't say I've ever advised a client to do that. It's a pretty serious thing as an individual, to go to the government, particularly if you're the wrongdoer or participated in the wrongdoing. So it's not generally in my advice to anyone unprompted who I think faces some liability to ever go to the government and self-disclose. Companies are in obviously a very different situation because they have incentives to self-disclose. Individuals generally do not have anywhere close to the same protections or possible protections. So I'd be very hesitant to advise someone to go to the government and self-disclose in that way, because you're putting yourself out there to be prosecuted as well. Just because the government is primarily investigating the company, under the Yates Memo and under the current thinking of DOJ, they are trying to go against individuals. So you are giving them an open invitation to come against your client. And so I'd be unlikely to advise my client to do that. And as I said, working with a company can be frustrating through a joint defense process, and the company has different interests than I do representing my client, but the company is often my best source of information to defend my client. So if I know something bad happened around a certain transaction, if I'm cooperating with the company at least, I may be able to get the relevant emails and put together a defense for my client and prepare for a proffer with the government. And if I'm not working cooperatively, if I go behind the company's back, I think I risk destroying that relationship entirely and maybe my chance of crafting a defense. I don't want to have to get indicted to get discovery to be able to come up with a defense.
So, Sarah, unfortunately, we're near the end of our time, but I was wondering if anyone wanted to reach out to you directly based upon your great blog post or what you've talked to us about on this podcast. Could they email you, and if so, how would they do it?
Absolutely. My email address is Sara, S-A-R-A, no H on that, just S-A-R-A, @ and then my last name, which is spelled K-R-O-P as in Peter, F as in Frank, and then a hyphen, and the word law.com. So it's Sara at Kropf-law.com.
Well, Sarah, I really appreciate you taking the time to visit with me. Once again, I'm going to ask to please blog more, because you put some great stuff up there, and I look forward to continuing the conversation.
I appreciate it. Thanks, Tom, very much.
Hello, everyone. This is Tom Fox again. I'd like to thank you very much for listening to this episode of the FCPA Compliance Report. I have two calls to action for you. If you are listening to this on iTunes, I would greatly appreciate it if you would rate this podcast on iTunes. It would help with our rankings. Also, I'm developing a list of questions for a mailbag episode. So if you have any questions, shoot me an email at tfox@tfoxlaw.com. I'd love to explore any questions you might have on an upcoming podcast. This is Tom Fox. I'd like to thank you very much for listening to this episode of the FCPA